Imagine getting a heavy income tax reassessment notice in the mail, and your lawyer confidently tells you to run it through the shredder. For a brief moment in time, that was actually viable legal advice, but that era is completely dead. Taxpayers used to have a very specific shield against reassessment notices, issued under Sections 147, 148, and 148A of the Income Tax Act. They argued the officers sending them simply lacked the statutory authority, the legal jurisdiction, to initiate the proceedings in the first place. Taxpayers had serious legal backing for this. The Bombay High Court's ruling in Hexaware Technologies validated the defense, declaring notices from these officers invalid. Word spread quickly. Taxpayers across the country adopted this precedent, confident they had a foolproof strategy to defeat income tax reassessments on a pure jurisdictional technicality. But the government refused to leave that door open. Parliament intervened to close the loophole and rewrite the rules of the dispute. Through the Finance Act of 2026, lawmakers introduced a brand new provision into the Income Tax Act, Section 147A. This section explicitly granted assessing officers the authority they allegedly lacked. This timeline shows how the amendment operates. It travels backward, taking legal effect retroactively from April 1, 2021. By applying this retroactively, every single reassessment notice issued during that 5-year window instantly flipped from questionable to legally valid. The legislative time machine wiped out the core defense strategy overnight. Thousands of taxpayers who thought they were safe on a technicality suddenly found themselves trapped under a newly validated law. The strength of this new law was recently tested at the Madras High Court in a batch of writ petitions heard by Justice C. Saravanan. The taxpayers who filed these petitions walked into court still relying on the old strategy, arguing their reassessment notices should be quashed because the officers issuing them had no legal authority. The specific officials in question are known as Jurisdictional Assessing Officers, or JAOs. These are the local tax officers assigned to monitor specific taxpayers based on their geographic area or income bracket. Looking at this diagram, Section 147A permanently links the JAO directly to reassessment authority, ending legal ambiguity. Because petitioners only challenge the JAO's authority, rather than the constitutionality of Section 147A itself, their defense collapsed against the retroactive law. The Madras High Court cemented the new reality. Attacking a tax officer's jurisdiction is a legally dead end. This outcome aligns perfectly with recent actions taken by the Supreme Court of India. The Supreme Court systematically went through and set aside earlier High Court judgments that had ruled in favor of taxpayers based on that old jurisdictional flaw. However, the Apex Court left one specific door open. While you can no longer argue the officer lacks jurisdiction, taxpayers remain completely free to challenge the constitutional validity of the newly inserted Section 147A itself. The highest court in the country has drawn a hard line. Standard evasion tactics based on technicalities are obsolete. If you want to fight a reassessment notice today, constitutional warfare is your only viable path forward. This split-screen diagram illustrates the critical pivot taxpayers have to make. On the left, a jurisdictional challenge attacks the specific authority of the officer. On the right, a challenge to the vires, or constitutionality, attacks the legal foundation of the law itself. But stepping into constitutional territory brings a major procedural hurdle. As Justice Saravanan noted at the Madras High Court, a single judge cannot decide a challenge to the constitutional validity of a statute. To have any chance of success, taxpayers must elevate their legal fight directly to a division bench, where 2 or more judges hear the constitutional merits of the case. The legal chessboard has leveled up. You can no longer win this game in standard single-judge proceedings. You have to prepare for a high-stakes argument before a constitutional bench. Despite dismissing the writ petitions, the Madras High Court did grant a pragmatic layer of protection. They issued a strict order preventing any recovery proceedings against the petitioners for 30 days. This 30-day grace period serves a highly specific purpose. It provides a temporary window for these taxpayers to pivot their legal strategy and file a new challenge before the division bench. For tax professionals and business owners, the message is clear. Discard the old jurisdictional loopholes. If you are facing a reassessment notice from April 2021 onwards, you need to prepare immediately for intense constitutional scrutiny. The battle over which officer has jurisdiction is over. The real war must now be fought entirely at the constitutional level.